The history of international law can be traced back to various historical events and developments, but one of the significant turning points came at the end of the 30 Years' War with the Peace of Westphalia in 1648. This period marked a new era in the evolution of international law, establishing principles that would shape the conduct of nations and the development of legal norms governing international relations. The 30 Years' War, which lasted from 1618 to 1648, was a devastating conflict involving many European powers, primarily fought over religious and political issues. The Peace of Westphalia, signed in 1648, brought an end to the war and introduced key principles that would influence the development of international law. These principles included the sovereignty of states, non-interference in domestic affairs, and the recognition of political and religious pluralism. The Treaties of Westphalia established the concept of state sovereignty, where states were recognized as having authority over their territory and the right to govern without external interference. This principle became a cornerstone of international law, shaping the interactions between states and the framework for diplomacy and conflict resolution. Following the Peace of Westphalia, the concept of sovereignty continued to evolve and gain prominence. The 17th and 18th centuries saw the development of the modern state system, where the recognition of state sovereignty became integral to international relations. This period also witnessed the emergence of diplomatic practices and the establishment of permanent embassies, which facilitated communication and negotiation between states. The ideas of Hugo Grotius, a Dutch jurist and philosopher, significantly influenced the development of international law during this time. Grotius is often regarded as the father of international law for his contributions to the understanding of legal principles governing the conduct of states. His seminal work, De jure belli aexi pacis, or On the Law of War and Peace, published in 1625, laid the foundation for the laws of war and the concept of natural law as applied to international relations. Grotius argued that natural law, derived from reason and applicable to all humans, should govern the conduct of states. He emphasized the importance of justice, fairness, and the protection of rights in international relations. Grotius' ideas influenced subsequent thinkers and the development of legal frameworks that sought to regulate the behavior of states and promote peaceful coexistence. The 18th century saw the codification of international law principles and the establishment of legal norms through treaties and conventions. One notable example is the Treaty of Utrecht in 1713, which ended the War of the Spanish Succession. The treaty not only settled territorial disputes but also included provisions on trade and navigation, reflecting the growing importance of economic relations in international law. The 19th century was a period of significant expansion and formalization of international law. The Congress of Vienna in 1815, which followed the defeat of Napoleon, aimed to restore stability and order in Europe. The Congress established a framework for international cooperation and diplomacy, promoting the idea of a balance of power to prevent future conflicts. The Concert of Europe, an informal system of meetings and negotiations among the great powers, emerged as a mechanism for maintaining peace and resolving disputes. During this period, international law began to address issues beyond territorial disputes and diplomacy. The abolition of the transatlantic slave trade and efforts to combat piracy were among the first humanitarian concerns to be addressed by international treaties. The Declaration of Paris in 1856, for example, sought to regulate naval warfare and establish principles for the treatment of neutral ships during conflicts. The latter half of the 19th century witnessed the emergence of specialized fields within international law. The Geneva Conventions, beginning with the First Convention in 1864, established rules for the humanitarian treatment of wounded soldiers and the protection of medical personnel during armed conflicts. These conventions marked the beginning of international humanitarian law, setting standards for the conduct of war and the protection of individuals in times of conflict. The Hague Conventions of 1899 and 1907 further developed the laws of war and introduced principles for the peaceful resolution of disputes. The conventions established mechanisms for arbitration and mediation, promoting the idea that conflicts should be resolved through negotiation and legal means rather than armed confrontation. The early 20th century saw the creation of the League of Nations, the first international organization aimed at maintaining peace and promoting cooperation among states. Established in 1920 after World War I, the League of Nations sought to prevent future conflicts through collective security and the promotion of disarmament. The Covenant of the League of Nations included provisions on dispute resolution, the protection of minorities, and the promotion of social and economic cooperation. Despite its ambitious goals, the League of Nations faced significant challenges and limitations. The absence of key powers, such as the United States, and the inability to prevent aggression by states like Japan, Italy, and Germany undermined its effectiveness. The outbreak of World War II exposed the weaknesses of the League of Nations and highlighted the need for a more robust international system to maintain peace and security. The end of World War II marked a turning point in the history of international law with the establishment of the United Nations in 1945. The UN Charter set out the principles and goals of the organization, including the maintenance of international peace and security, the promotion of human rights, and the advancement of social and economic development. The UN introduced a new framework for international cooperation, with a system of collective security and mechanisms for conflict resolution. The International Court of Justice (ICJ), established as the principal judicial organ of the UN, provided a forum for the peaceful resolution of disputes between states. The ICJ's jurisdiction and decisions have contributed to the development of international legal principles and the peaceful settlement of conflicts. The post-World War II period also saw the creation of a comprehensive body of international human rights law. The Universal Declaration of Human Rights, adopted by the UN General Assembly in 1948, articulated fundamental human rights and freedoms to be protected by all states. Subsequent international treaties, such as the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, further elaborated on these rights and established binding legal obligations for states. International criminal law emerged as a distinct field with the establishment of the Nuremberg and Tokyo tribunals after World War II, which prosecuted individuals for war crimes, crimes against humanity, and genocide. The creation of the International Criminal Court (ICC) in 2002 represented a significant development in holding individuals accountable for the most serious international crimes. The ICC's establishment signaled a commitment to ending impunity for perpetrators of atrocities and strengthening the rule of law at the international level. The latter half of the 20th century also witnessed the development of international economic law, driven by the need to regulate trade, investment, and monetary relations in an increasingly interconnected world. The General Agreement on Tariffs and Trade (GATT), established in 1947, sought to promote free trade and reduce barriers to international commerce. The creation of the World Trade Organization (WTO) in 1995 built on the foundations of GATT, providing a more comprehensive framework for regulating international trade and resolving trade disputes. International environmental law emerged as a response to growing concerns about the impact of human activities on the environment. The Stockholm Conference on the Human Environment in 1972 marked the beginning of global environmental cooperation, leading to the adoption of international treaties addressing issues such as pollution, biodiversity, and climate change. The United Nations Framework Convention on Climate Change (UNFCCC), adopted in 1992, and the subsequent Paris Agreement in 2015 represent significant milestones in international efforts to combat climate change and promote sustainable development. The end of the Cold War and the subsequent rise of globalization further shaped the development of international law. The increased interdependence of states and the emergence of new global challenges, such as terrorism, cyber threats, and transnational crime, highlighted the need for enhanced international cooperation and legal frameworks to address these issues. The establishment of international organizations and mechanisms to combat these threats, such as Interpol and the Financial Action Task Force (FATF), exemplifies the evolving nature of international law in response to contemporary challenges. In recent years, the development of international law has been influenced by the rise of regional organizations and the increasing importance of regional legal frameworks. The European Union (EU), for example, has developed a comprehensive body of law governing various aspects of economic, social, and political life within its member states. The African Union (AU) and the Association of Southeast Asian Nations (ASEAN) have also contributed to the development of regional legal norms and cooperation mechanisms. International law continues to evolve in response to new challenges and opportunities. The proliferation of international treaties, the growing importance of international organizations, and the increasing role of non-state actors in shaping legal norms reflect the dynamic and multifaceted nature of the field. The principles established by the Peace of Westphalia, such as state sovereignty and non-interference, remain foundational, but they are now complemented by a complex web of legal obligations and institutions that address a wide range of global issues. The future of international law will likely be shaped by ongoing developments in technology, shifts in global power dynamics, and the need to address emerging challenges such as climate change, cybersecurity, and global health crises. As the world becomes more interconnected, the importance of effective and adaptable international legal frameworks will continue to grow, ensuring that states and other actors can navigate the complexities of global relations while promoting peace, justice, and cooperation.